The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
We have three cases before us this afternoon. The case of Dolly Investments versus MMG Sioux City is hereby submitted without oral argument. Our first case for oral argument is State of Iowa versus Rick Petro, and it looks like counsel are ready. Ms. Anderson, are you ready? And Ms. Hines? Okay, Ms. Anderson, you may begin.
May it please the court, counsel. Good afternoon. My name is Karmen Anderson, and I represent the applicant in this case, Rick Petro. The court is fond of saying that the best predictor of future behavior is past behavior. Well, let me tell you a little bit about Rick Petro. He's 61 years old. He resides in Carlisle, out on Cleveland Street, where he has lived for more than 25 years. He drives a truck delivering fuel to gas stations all across the state of Iowa. Now, Mr. Petro has exactly 2 criminal convictions in his 61 years. Well, I guess you could say 3 if you count the traffic ticket that he received in 2019. Back in 2009, Mr. Petro was charged and ultimately convicted of assault causing injury, a serious misdemeanor. He pled guilty to striking Suella Petro on her shoulder, causing redness. In 2011, he was then convicted of a simple misdemeanor for violating a no-contact order that was put in place in that case. In that matter, he spoke to Ms. Petro during a court proceeding, which of course was a violation of the no-contact order. Now, in each of those cases, Mr. Petro took responsibility for his actions. He pled guilty in those cases. Now, since 2011, other than the aforementioned traffic ticket in 2019, Mr. Petro has not been charged or convicted with any criminal offenses in more than a decade. Now, prior to 2009, when Mr. Petro was 48 years of age, he had not even had a traffic ticket on his record. Yes.
Would I be correct in saying that the whole time you're saying what he hasn't done, no criminal records, we're also talking about a period of time where there was a protective order in place, right?
Protective order was entered in August of 2009, and it remains in place to present day. That is obviously the subject of this application for further review. And so although I would agree that, he hasn't had any acts or anything like that against Suella during the time that this protective order is in place, I think it's also very informative that he hasn't had any other interactions with law enforcement or the criminal justice system during that time.
Violence is all about, though. Domestic violence is a different creature. I mean, you can have a lily clean record, but a relationship that goes south oftentimes brings out the darkness in people that the rest of the world doesn't see.
Absolutely, Judge, that can happen. And we do see it every day in the court system, whether you do criminal law or family court. We see a lot of domestic violence that comes to light during a marriage or significant relationship. But I think, you also can't just look at the one relationship between Rick Petro and Suella Petro to make that determination whether he's a violent person or something of that nature. You have to look at the surrounding history. I mean, we don't have any 236 civil no-contact orders ever filed against Mr. Petro, so no other relationships.
As far as, has he completed the batterer's education?
That is in the record. As part of the probation reports filed in this case, you will note that it was a requirement of his probation that he complete batterer's education, and he did so, Judge, along with probation. Additionally, as testified to by Mr. Petro, and I can't recall if it was ordered in the disposition, but Mr. Petro also did a significant amount of therapy, 6 years.
You could have brought the therapist in and had the therapist testify about, not only did he complete the therapy, but he did put the anger issues behind him, but you didn't. In advance, that was one of the pieces of information that the defendant used to meet his burden. And do you agree with me that it is Mr. Petro's burden? And what do we do with it when all we have is his word to go on?
Well, Judge, I agree. We could have absolutely brought in the therapist and had the therapist testify to all the work that Mr. Petro had done during his time in therapy. One of the reasons, of course, is that we didn't do that is because his therapy completed in about 2015 or so. And we're now doing this in 2021, 6 years after the fact. So yes, you do have to rely on Mr. Petro's testimony if you want to believe that he did attend therapy for 6 years.
Therapy and completed therapy actually contested at the hearing?
Nobody questioned that, and although it's not part of the record, I will tell you that the court was aware through other proceedings involving Mr. Petro that he had been involved in therapy. That would have also been a factor as to why a therapist was not brought in, is because it really wasn't a disputed issue. Ms. Petro was well aware of it. Mr. Petro, had in the past made reports and stuff available to Ms. Petro and the court. So it really wasn't an issue in dispute. And like I said, just given the fact that we're 6 years removed from the completion of therapy, it doesn't make it as feasible to bring in the therapist as it might have been had we just been a year removed or a few months removed.
Recognize that or agree that it is your client's responsibility. Under the statute, the no contact order shall be extended unless your client establishes to the court's finding that he no longer poses a threat. And so what do we do with that burden that's on your client?
I agree that the court has indicated that is my client's burden. And as this court's well aware, it's very difficult to prove a negative, right? All we can look to is things, the objective evidence, right? That's what the court requires, is that we look at objective, not subjective evidence, which is why we don't just rely on the victim's statement that she's afraid of a defendant or something like that. And when you look objectively at the evidence, I mean, you can see, like I said, one of the big factors in this is the isolated criminal activity that Mr. Petro engaged in. I mean, we have about a 1.5 year period where he committed wrongs. He doesn't deny that. Like I said, he took responsibility in pleading guilty. He didn't require a jury to come in and find him guilty or tell him that he had done something wrong. He took responsibility for those poor actions that he took. And then, of course, like I said, I don't know how many in this courtroom.
Initially, he had trouble taking responsibility. In other words, he did violate the no contact order at the beginning, correct?
Yep, actually, he had 2 violations. None of them were actually like where he had, like he didn't physically go to Suella Petro's house or anything like that. One was a statement that he made during a visit with his children to an FSRP worker, not to Ms. Petro directly. And then the next was, like I said, he did talk to her in a courtroom when they were all together, which was a violation of the no contact order.
Bit in time. It's really easy to look at the facts now, and it looks as if the dust has settled. I have faith and confidence in court's orders. Now, I know they're not always followed. I was a presiding judge at many times when my own orders were being violated. But all in all, when they're being followed, that is what is expected of people, and they actually are ordered to do so. So I kind of liken this to a parole hearing. So while somebody's in prison, the victim feels safe, and as soon as they start having parole hearings, all of a sudden they come back and they talk about the initial crime. I don't see much in the record about the initial crime, but from the Court of Appeals opinion, even after the no contact order was entered, another 5-year contact was entered, again, I think more than once. And in one particular situation, in April of 10, he violated the no contact order, and apparently what he said is, and I apologize for what he said, but it shows, I think, the gravity. If his wife didn't keep her mouth shut, he was going to take a fucking ball bat to her head. Now you go to the transcript in this case, and one of the reasons he's asking for this to be lifted is so he can hunt. And I can't help but liken that situation to how she may have felt. I mean, and she probably believed he would take a ball bat to her head. So I think just the following. I'd rather you talk about, if you could help me understand the nature of the original offense, which was pretty egregious from what I can read, and why we can't assume that the evidence that you presented, or you or your whoever represented him at the trial level, had the burden and didn't quite meet that burden, and that we can't take the history into consideration.
Obviously, the court's most recent case, Huber v. Polk County, the court reiterated this court that you can consider the history and the underlying nature of the offense when deciding whether or not to extend the no contact order. What I will say is that Mr. Petro was convicted of a serious misdemeanor. That's a relatively low-level misdemeanor offense. So it is not, we're not talking attempted murder or anything like that, something so egregious. Another interesting thing is when I was thinking about this case, a few years ago in 2019, our legislature amended one of our expungement statutes.
You said a serious?
Yes, Judge.
Charged with an aggravated. He pled to a serious. I'm looking at the trial information.
He pled guilty to a serious misdemeanor, assault causing injury, Judge.
The other charge that he was charged with was an aggravated.
If I remember correctly. That was ultimately dismissed. But he pled guilty to the serious misdemeanor, so that is all that he was convicted of, Your Honor. But what I noticed about that conviction was that when our legislature amended the expungement statutes, one, they put a time frame. They said that if you have no criminal offenses pending and it's been 8 years, even though you were convicted of this, we're going to let you wipe it clean from your record. We're going to allow you to expunge it from the public record. It can no longer show up there and be used against you. And they also then exempted certain crimes from that list, saying, you know what, we're not going to let you shove those under the rug, right? We're going to make sure those stay on your record till the end of time, unless you go to the governor or seek some other pardon. But notably, 8 years was the time frame that they imposed. I mean, we have 13 years since this charge, but also
Standard of review that we're reviewing the district court's decision on.
the standard of review is for correction of errors at law, Judge, so if the court,
Substantial evidence. I mean, the burden of proof is on you, but whichever way the court ultimately goes, there needs to be substantial evidence to support what the court did.
court's factual findings are binding if supported by substantial evidence in the record. So yes, so the review is for correction of errors at law, but then of course you have to then consider whether or not there's substantial evidence to support the district court's factual findings.
I mean, it is, the burden is not on the state to prove that your client is still a risk or a danger. The burden is on you to prove, your client to prove otherwise. That's is unusual. I mean, there's a reason for it. There's a reason why it's done that way, but that's unusual, and it maybe complicates our review a little bit, doesn't it?
Complicates how we present the evidence, because like I said, it's extremely challenging to prove a negative. All you can,
Affirmative evidence that he remains a threat to her or anyone or her children.
record, Judge. I mean, and that is our position. Ms. Petro did voice that she still had a fear of Mr. Petro, but there's absolutely no evidence. Like I said, looking at the criminal history, looking at what he's done, there are no indicators that he would still continue to be a threat to her. I did something else too. So yesterday, I Googled the population of Carlisle, which is about 4,100 people. It's also 5 square miles. So that's a very small town. As noted in the record, Mr. and Mrs. Petro both have resided in this very small town during the 13 years that this has been going on. And during that time, definitely during the preceding 5 years, but even during the last 10, Mr. Petro has never violated that no contact order. Now, I would submit that you have to make a conscious effort not to violate the no contact order in a town that is only 5 square miles. Right, exactly, Judge, yes, you know, he's had to make an effort not to go to the local Casey's, not to go to the local Dollar General, and he testified to some of that. But he has made a concerted effort to ensure that he follows this court order for not just 1 year, 2 year, 5 years, like some of those other cases that we reviewed, but for 11 and a half years.
I understand, as I recall, his parental rights were terminated, but what does the record show about the age of the children? Because if they were still young and around, that might give some basis for him to interact.
Knowledge, because I've represented Mr. Petro for a number of years, so I can tell the court. Yeah, I don't know if it shows.
That would be certainly in the record. How old are they now?
I think the youngest is around 20, if I recall, maybe even older, and then the older one is a few years older than that, but I don't recall the exact age, Your Honor. I see that my time is up, so I will just reserve the remainder for rebuttal. Thank you.
May it please the court, counsel. Iowa Code Section 664A.8 prioritizes the safety of the victims. And one way it does that is by, although not strictly in practical effect, requiring the defendant to prove that he is no longer poses a threat to the victim. I think that's important because the assumption is that the court will continue a no contact order upon the request of the victim unless, so the default is that the order continue if the victim applies for an extension.
Sufficient evidence to prove the negative.
I think that sufficient evidence would be to bring in a witness. In this case, the logical witness would be the therapist, who could testify that the defendant had worked through his rage issues and no longer was obsessed with his ex-wife or meant any harm to her. I think that you could probably, if the therapist was no longer around or the treatment was so long ago that it was not possible to bring him in, there's other people in the community that could come in and testify to.
Hard on the other side for kind of some practicality. I'd like to, what's fair is fair. Many times our orders are treated nothing more stronger than the piece of paper that they're on, which is really sad and unfortunate. And if somebody wants to get to somebody, they're going to get to them. And so for him to go now 10 years, 12 years, would you agree with me that that's quite remarkable?
Your Honor, I would think that that was exactly what he was supposed to do pursuant to the no contact orders. And there's case law to say that the mere compliance with the no contact order does not foreclose the idea.
Say, if the court were to say, that's just not enough recent information, we don't find that to be a reason to renew it, and something happens tomorrow, can't she just go get another order?
Well, I think the idea is to prevent something happening tomorrow.
The level of, if something happens, I agree, the egregious, nobody would ever want to condone that. But my point is, if the court is wrong, or if people are wrong, and it continues, even if it would just be phone calls or some sort of nature, couldn't she seek another one outside of this proceeding?
Seek one under 664A.8. She could seek one under, and I'd like to talk about that a little bit because the case law is kind of meshed together with protective orders entered pursuant to Iowa Code Section 236.5, and there are different standards and different burdens of proof. Much lesser in the 236.5 context. For one thing, it's permissive for the court to grant an extension. It says the court may. In this case, we've talked about Section 664A.
But you would agree that the order does, in a significant way, interfere with Mr. Petro's civil rights. I mean, he lives in a small town, and he has to be very careful how he goes around and where he goes in that town in order to avoid meeting his ex-wife. Isn't that correct?
The legislature has made it a decision that the priority is the victim's safety rather than the defendant.
But it also means he can't legally own a firearm, which is something that probably many of the people sitting in this room presently do and have the right to and most or all of us have the right to do. I mean, those are significant interferences.
Brief, so I'm hesitant to remark upon it, but since you've asked, there is a statute already that would prevent him from having a gun just by virtue of his conviction of a misdemeanor domestic assault. That's 724.26. So regardless of the presence of the no contact order, Mr. Petro cannot own a gun.
So as a factual matter, was this a domestic? Is that what he pled to? I thought he pled to.
Section 624.26, they don't look at the official name of the crime, they looked at who the victim was. And they were married at the time that this crime occurred. And that's important to advance, that the nature of the crime is also looked at. And this is a crime.
This is strange to say, but doesn't that cut against you? Because that was a point that was cited by the district court in its ruling as one of the things they were concerned about is if the order was lifted, he'd be able to go get a gun.
Because the district court can take that statement from the defendant and look at his tone and observe him and decide that doesn't sound quite right to me, the way that he said that. Or it might, in his knowledge, this district court is the same in every proceeding since the original sentencing no contact order. It has a read on these two parties for over 11 years. And the district court could take that remark and desire for the defendant to have a gun in a way that defendant didn't mean it, but the district court just...
But yes, I mean, one thing that struck me, reading from the transcript, there was, he was asked at one point about the parental termination of parental rights hearing, and he would say it was arguably the worst day of my life, and the court held that against him. I'm quoting from the transcript. Is that? I mean, I think most people, if that happened to them, would say that was the worst day, arguably the worst day of their lives. I mean, I think if that happened to me, it would be the worst day of my life.
Denial of his reconsideration motion mentioned that, but maybe it did. Regardless, what I was going to say is that because it's the worst day of his life, and that goes to the nature of domestic violence offenses and the purpose of no contact orders, these issues are, lifelong and continue to...
If you're correct that he even separately cannot own a gun, and the district court partly said he still poses a threat because he wants to get a gun, does that mean that the district court misunderstood what the law was and maybe relied on a factor he should not have?
I suspect that the district court misunderstood, and I think that the district court's consideration of that was reasonable because he read it. I think the district court clearly read that desire on defendant's part to own a gun as worrisome. And that in the Huber, I think it was, the district court would listen to the defendant talk about no interest in, contacting his victim, and the district court disregarded that. It just found that not credible. And this district court, again, who's been involved all through this process, can probably be, or is in the best position to read.
That's there to support the state, because I'm having a hard time. I think you'll agree with me. What you're presenting to the court, or what was presented to the court on that day, even by defense, would never be enough probably for a 236 petition. Would you agree with me?
Evidence presented at this hearing, yes. Yes.
Probably wouldn't be enough for an assault, wouldn't be enough for harassment. What would it be enough for?
I actually take back my statement that it wouldn't be enough. I think if the district court, again, sized up the defendant's statements and found that that was enough, and it had...
Because grandma and grandpa driving by his house 5 years ago doesn't cut it with me.
Well, I think you have to look at the length of the parties' relationships, and you can look back at things that happened years ago. I think
Questioning to defense counsel earlier, I do give great weight to the severity of the crime that occurred that led to this conversation today. But when you ask for renewal of a protective order, there needs to be something for the court. And I know the burden's on the defendant, but tell me, what is it that is so obvious to tip those scales. Yeah.
Require that anything happen and that there would be a violation of the no contact order.
Said it's the defendant's burden, and the presumption is it's going to happen. It shall happen unless. So to me, unless means tip it. What tipped it?
The district court and a different defendant might have come across differently to the district court, and he might have felt.
The court found, I mean, this is what, I'm just going to read the order, this is what the court said in its order. First, it cites the convictions and the prior violations, which are not disputed. Then it says the victim testified that the parents have driven by her home without cause. She believed that the defendant had sent them there. The court, we agree, was confused about that. That incident happened 10 years before, not in the, or whatever, not in that, or prior to the previous renewal, not at this point. The defendant testified that the time of the termination of his parental rights were the worst days of his life. That's the second item. And then, and that, that is true. That's what he testified to, but that doesn't strike me as very substantial in evidence. And then the third thing is the court is concerned that the defendant also wants his rights to bear arms reinstated, albeit as to hunting. And the state's position is that even though he was not convicted of a domestic violence specific crime, under these circumstances, he would still not be allowed to possess arms. So where is the substantial evidence in all of that?
It was defendant need to put on substantial evidence.
They bear the burden of proof, just like if in a civil case, the plaintiff bears the burden of proof. But at the end of the day, we'll reverse judgment for one side or the other if we say that there's no substantial evidence supporting what the ultimate outcome was, right?
You start with the position of default, which is that the order shall continue unless. And I think that just places again, a priority on the victim's feelings about it, though such that she went and attempted to renew these and successfully renewed these.
Are these effectively a life sentence whenever the victim wants it extended? If the defendant who has obeyed the order to the letter, he's got to live with it for the rest of his life?
I think that the general answer to that is yes. I think it would be unlikely that somebody would be unable to show for a lifetime that they were not a threat to the victim. But I think in theory, yes.
Or age 90, he could still be under this protective order?
Age, maybe the court think that he no longer posed a threat to the victim. You know,
Kind of more subtle question. The statute says that the order shall continue unless the defendant shows, or unless the court, I don't even think it says the defendant shows, it says the court finds. So I'm not entirely convinced on this burden of proof issue, but there's not a presumption of dangerous going into the hearing. Do you agree with that? It's a presumption the order shall continue, but not a presumption of dangerous unless the defendant proves otherwise.
I suppose is the threat to the victim. There's a presumption that he continues to pose a threat to the victim.
The order shall continue unless there's a finding of not dangerousness. I'm not sure that's necessarily a presumption of dangerousness, kind of as an evidentiary or factual matter. Do you agree with that or no?
No, I don't. I think that the statute is written in a way that understands domestic violence and understands the nature of it and puts the priority on the victim's feeling of safety.
But that worked, I mean, in a sense, that worked in this case, because if you read the transcript of the hearing the 5 years before, the defendant there's a real edge to him there, and that was picked up on by the district court and by the Court of Appeals, and they said, reasonable fact finder could find he has not worked through his anger issues. You know, there are things like, there was one question was asked, what have you done to demonstrate to this court that you have overcome the anger issues that led you to assault the victim? And he answers, well, first of all, I haven't been in any trouble since this incident, and right now I believe I'm more calm and controlled than you are. And one could read that answer as being kind of a little bit belligerent. And that does, to me, that system worked there for that 5-year renewal. But now what do we have here on this 5-year renewal?
This hearing in which he, I read it as kind of overcompensates for the idea that he can't have contact with her by not knowing where he can look in the hearing. And the district court finally says, just look at me or your counsel.
Burden thing, and I think we've talked about it enough. I think everybody agrees defendant has a burden. Would you I think it's fair to assume that in a sense, okay, they volleyed the ball. They said, I haven't broken the order in 5 years. I successfully completed mental health treatment. I took the batter's education program, and it is hard to prove a negative. Short of that, they don't have an incident to talk about because that's their whole point. They have nothing to talk about. Doesn't that kind of at that juncture shift the burden to you? Okay, state, what you got? What you got? Just because they had to start doesn't mean you just get to sit on your hands. Where's the meat? What is there?
I'm almost out of time. May I answer your question? That's what we're supposed to do. Well, the thing is, or the thing that I think you're concerned about is understandable, but that's not how the legislature framed the statute. It framed it as victim-friendly, and to get out from under a no-contact order, you have to be showing something that the court can really put, that can give you the meat that the court need to find that you're no longer pose a threat. And a therapist, I think, is the most logical way to do that. If you have a therapist come in and say to the court that this man has no interest in his ex-wife, he is not violent, he doesn't want a gun for anything but honey or et cetera, that would be sufficient to show that he was no longer posed a threat to the victim. Thank you.
Ms. Anderson.
Well, I'm not sure where to begin with all of that. This idea of bringing in the therapist has been thrown out a number of times, and so if that's the standard that we're going to employ, are we going to employ it on all cases or just Mr. Petro's? Because we have a number of cases where the defendants have not had the no-contact order renewed, or it's been lifted where they didn't go to therapy, they didn't complete that. That's just an extra step that Mr. Petro took in his case because of everything that was going on, because going through the termination of parental rights was the worst period of his life. So he took that extra step. He continued it long after he was off of probation, long after he was out from underneath the district associate court's thumb. He continued to do that for his own good, for his own benefit. I mean, I think we've overlooked that.
About the therapy that he went to. He testified that he completed 6 or 7 years, I think. Is there more beyond that? Did he say the things that you're saying here, other than I went to therapy and I completed it?
It's hard to say because this has been going on for so long and there's multiple records in this case. I believe it was testified to at the last 2016 hearing on the extension, and then it was also discussed at the 2021 hearing. Whether or not he got into the specifics of that therapy, I don't honestly recall, Judge, off the top of my head. Because
one question, did the district court make any credibility findings? So when he said, I completed the 6 to 7 years, did the district court say, I don't believe you, or make credibility findings one way or the other?
Absolutely not, Judge. And in fact, in the previous order, there were no findings that Mr. Petro was not credible in his testimony. The district associate court merely found that he still continued to pose a threat and then recited the couple of reasons in their order that it found in that manner. So no, and as we well aware, it's many a court has made credibility findings in their orders, especially if that's what they're basing their opinion and ruling on. And in this case, we don't have that in either of the last court rulings.
Vance, they called a police officer to testify that the defendant had never been prone to violence or posed a threat to the safety of anyone. Is that something that you could have called, presumably the officer in Carlisle would know everybody.
know my client, Judge, because he hasn't had any interactions with law enforcement for the last almost 12 years. So I'm not sure if he would have been able to call law enforcement. Now, there's a distinction in Vance, because Vance, I believe, worked for like the probation office or something like that. So he worked in the law enforcement community. So of course, he had coworkers and different things that would have been law enforcement officers that he could call in to testify. And I mean, again, Mr. Petro could have paraded in, 10, 12, 15 people, and I suppose if the court doesn't grant it, that's the tact we'll take next time. Yeah, he could have, just as, Ms. Petro could have also called in witnesses to say, hey, here's.
Rebuttal. But how about not only witnesses, but exhibits? Were there any exhibits?
Not in this go-round, Judge.
Not really.
Judge, in part because there's nothing to exhibit. If like I said, if he had had some kind of other crime that he'd been committed, that could certainly be put on display and entered as an exhibit. Anything. I mean, like I said, if there'd been a 236 order filed against him by some other spouse or girlfriend.
It would come before me when somebody wants to prove that they've been walking the straight and narrow. For example, I've been in a long-term relationship for 5 years with someone else. We've never had any violence there. I mean, a lot of times a violent person is going to be violent in another intimate relationship too. It happens. So I don't think I have to get too creative, but so there were no exhibits and no witnesses, right?
For that, Judge, because we don't have any 236 ever filed against Mr. Petro. So doesn't the record exhibit that look, he hasn't had these violent relationships. He hasn't had people.
For 9 years before, and then he was only convicted once, but after a 9-year period of violence, if you believe what she said.
If you believe, but again, that's the historical aspect of it, right? And again, I would do what I do in every cross-examination. Well, did you ever have the police come out to your house? Were there, any other criminal charges filed? Did DHS ever get involved? And all of that would be answered in the negative in this case because we don't have anything prior to that. So I would say that the allegations that they had been violent for 9 years is questionable. Also, remember these people, I don't know how much you recall, but they adopted the children that were in their house. So DHS had come in many times and examined their household and interviewed them and found them to be suitable. So I see that I'm out of time, so thank you, Your Honors.
The case of State versus Petro, which I mispronounced the first time, and I apologize. Figure his lawyer knows how to pronounce it. Is hereby submitted. And we will allow there to be a transition for our next case, State versus Torres.